for the next session. The next session that was introduced by Marie-Claire will be a high-level plenary taking stock of legal progress on climate change, co-chaired by Professor Christina Voigt, who is with us here in the room, and online by Advocate Douglas Leys, who spoke earlier, and we can see on the screen right here. So I'll be giving the microphone to my dear friend, Christina, so that she may introduce her segment. Thank you.
Thank you so much, Ayman Shakawi, for your kind introduction. And thank you again, Marie-Claire and University of Middlesex for bringing us here together. We start right away with the first plenary. And what topic is more fitting than compliance, implementation? Where are we with the Paris Agreement? Taking stock of legal progress. And I guess there's a lot that can be said. I will speak in a little while, but I would like to introduce our beautiful and excellent members of the panel. We have with us here Professor David Voigt, the United Nations Special Rapporteur on Human Rights and Climate Change. Professor Payam Akhavan, a very, very central person in the current proceedings on an advisory opinion from the International Tribunal on a Law of the Sea, as well as the request to the International Court of Justice. We also have with us Professor Patricia Kameri-Mbote online, and my co-chair, David Douglas Leys. Douglas, can I give you the floor? Hi.
Yes, thanks, Christina. It's good to see you once again, and all my colleagues from Climate Law and Governance Day Initiative, especially my colleague Gulen from the Green Climate Fund, from which I hailed and was recently the General Counsel, and Gulen has succeeded me. I think it's the first time we're sharing a platform together, so it's good to see you all. And this is a great event. I think it is a segue of things to come. The topics are really diverse over what we have to look at today. And this topic in particular, I think, is the right, puts us in the right mode for kickoff, where we have a global stocktake of legally what has been happening, what has been done, and where we want to go with this particular aspect of climate law and governance. So I will, without any further delay, hand over to you to introduce the first speaker, Christina, and I think that would be yourself.
Well, in that case, Douglas, I'm happy to say a couple of words on the core question that you all see here in the program: what progress has been made in law and governments to respond to the climate challenge, and what more is urgently needed, in particular with regard to the implementation of the Paris Agreement and compliance with its rules. And it's a pertinent question to me, I guess. As Marie-Claire mentioned, I am the co-chair of the Paris Agreement Implementation and Compliance Committee, which is a core architectural element in the Paris Agreement. It is put in place and custom designed so that parties have a place to go to if they are encountering challenges in terms of their implementing capacity with the core legal obligations of the Paris Agreement. But the committee also has the function to promote compliance of the provisions with the provisions of the Paris Agreement. Now, as you perhaps know, last year at the last COP in beautiful Sharm el-Sheikh in Egypt, the governing body of the Paris Agreement adopted the rules of procedure for the compliance committee, and that enabled the committee to become operational for the first time. So this year, the committee had its first 2 initiations. It looked at 2 cases where parties were late in submitting mandatory information. And in a facilitative way, the committee was able to reach out to parties and kindly reminded parties, those 2 parties, of their obligation to submit that respective information. And what happened was very positive. Both parties reacted positively and within no time, within just a couple of weeks, submitted the information. In one case, it was the nationally determined contribution. In another case, it was finance information, which shows, in a way, that the committee works. It functions according to its rules, but it is also accepted by the parties that when the committee is raising its visibility, its voice, parties do react in a constructive manner. And that is absolutely crucially important because we're looking at the years ahead, which are core years in terms of Paris Agreement implementation and compliance. And what am I hinting at? I'm hinting at a very important deadline next year. At the 31st December 2024, from every single party, the first biannual transparency report is due for the first time ever. And it's a very important element because in those biannual transparency reports, party will have to include information on how they are doing in implementing and achieving their NDC. Every single party will have to do that. And the Compliance Committee, it's a legal obligation to submit that report, and the Compliance Committee will have a look at whether parties actually are submitting their reports. And then the next year, 2025, what's important about 2025? That's the year where every single party will have to communicate a successive nationally determined contribution. It's also the first time the requirements of progression and highest possible ambition apply to every single party's NDC. Very important. So we are looking at a crucial moment where the Paris Agreement is now kicking into motion. Of course, we're all impatient. It's not enough. NDCs are not enough. But it's very important to know the rules, to stick to the rules, and to focus on these very significant moments in time. The second comment I wanted to make, and it's already a segue to our first speaker, to Professor David Voigt, is that what we've seen in the last year or few years is the wider application of climate law to other areas of law, to look at other instruments, other rules, other obligations in the context of climate change and move in a way beyond the Paris Agreement. The Paris Agreement cannot give every single answer to everything climate change related. But we've seen a closing bridge between human rights and climate change, having now 9 cases at the European Court on Human Rights where the core question is the interpretation of the European Convention on Human Rights, which doesn't mention climate change or environment anywhere in the context of the climate emergency. We have 3 advisory requests for advisory opinions pending at international courts, and I'm sure Payam will talk about this in much more detail, where the question of human rights is also a core issue, as well as the application of the law of the sea to the climate emergency. Again, the United Nations Convention on Law of the Sea from 1982 doesn't mention climate change. It does mention the environment, but it will have to be interpreted in a evolutionary or dynamic fashion. So we see a widening of the discourse on climate change crossing over to other areas of international law in order to create an international legal system that is fit for purpose to promote climate justice and human rights for all. I think I'll leave my brief introductory remarks at this, and I'm very, very pleased to give the floor to you, David, to hear from your experience.
Well, thank you very much, Christina, and thank you for the opportunity to join you today. My friends, the climate crisis is a human rights crisis. As we sit here in this air-conditioned room, in this beautiful campus, in one of the wealthiest countries in the world, I'd like to use my privilege to bring to this gathering the voices of some of the people I've met during my journey as the United Nations Special Rapporteur on Human Rights and the Environment. My first country mission was to Fiji, where I visited a community called Vunidogoloa, one of the first communities in the world that had to be completely relocated because of the climate crisis. Surging seas, increasing sea levels, the saltwater contamination of their water supply, their croplands. So this community has had to move it inland by 2.5 kilometers. And that has profound implications for their human rights. It is a community that lived by the sea. Their culture, their food, everything depends on the ocean. And now elderly people, persons with disabilities, pregnant women, young children are cut off from the heart of their culture. When I went to Chile, I visited a community that in the midst of what they call a mega drought exacerbated by climate change has no water at all. In Petorca, I spoke to a beautiful 17-year-old girl who said, we have no water in our house, we have no water in our school. How am I supposed to have menstrual health in these conditions? They get a water truck delivery on an irregular basis. When I went to Portugal, I met with survivors of the deadly wildfires who are still struggling with post-traumatic stress disorder. When I went to Botswana just recently, I visited an indigenous community in the Kalahari Desert who told me that the heat is becoming unbearable. It's affecting their water supply. It's exacerbating human-wildlife conflict. It's affecting food security because elephants are desperate as well for food and are eating the crops of these indigenous people. And in a community called Kuke, I saw a huge lineup of women and girls at one of 2 water pipes serving a community of 1,300 people lining up to fill water jugs and containers. So the climate crisis is making life that in many parts of the world is already challenging, making it extraordinarily difficult. And this violates the rights to life, health, food, water, the rights of the child, and of course, cultural rights, and my personal favorite human right, the right that I think has the potential to accelerate climate action, the right to a clean, healthy, and sustainable environment. This right was recognized by the Human Rights Council in 2021, the General Assembly in 2022, the Committee on the Rights of the Child in 2023. It's also been recognized by the Committee on Economic, Social, and Cultural Rights, the Committee on the Elimination of All Forms of Discrimination Against Women. It was included in the Sharm el-Sheikh outcome document. It was included in the Kunming-Montreal Global Biodiversity Framework, and it is being put into action all around the world. And why are human rights such an important tool in the battle to address the climate crisis? The number one reason is because human rights clarify state obligations and business responsibilities. They also focus our attention on people in situations of vulnerability and marginalization, those who are being most directly affected by this crisis. But the human rights-based approach compels governments to provide people with information on the crisis, the opportunity to participate in decision-making, and critically, access to justice where their rights are being threatened or violated. And so, as my friend Christina mentioned, there has been a proliferation of really groundbreaking litigation across the world in the last 5 years, with courts in the Netherlands, Germany, Belgium, ordering governments to accelerate climate action. In Belgium, just within the last couple of weeks, a 55% reduction by 2030. The German government, in response to the Neubauer case, a 65% reduction by 2030. These are the levels of climate mitigation action that we so desperately need. In Brazil, Colombia, and Mexico, the highest courts have said that the right to a healthy environment creates an obligation upon governments to end deforestation. In Ecuador recently, the Constitutional Court said that the flaring of natural gas, which is happening just out the window here in the United Arab Emirates, is a violation of the right to a clean, healthy, and sustainable environment. In the Supreme Court of Hawaii this year, the court ruled that the application to build a biomass power plant, which many people think is a solution to the climate crisis, it's actually a false solution. Combustion is not the solution. The state Supreme Court of Hawaii said that violates the state constitution, which includes the right to a healthy environment, and critically said that the right to a healthy environment includes a safe, stable climate. That is what we were all working towards, a safe and stable climate. And so these cases are pointing us in the way forward. And I'd just like to, as my time is running out, 2 other things I'd like to quickly mention. One is that in the effort to achieve global recognition of the right to a healthy environment, one of the major impediments was governments fearing that they would be sued for not taking enough action. That was already happening. It's continuing to happen. But what's been really amazing in the last couple of years is that governments are now using the right to a healthy environment as a shield against industry and corporate litigation challenging climate and environmental action. So for example, we have cases where in the Philippines, fishing regulations were challenged by the fishing industry. The Supreme Court of the Philippines said these regulations are the government's fulfilling their obligation to protect the right to a healthy environment. We have cases from Kenya and Uganda where plastic bag regulations were challenged by businesses. And those courts again said governments can use the right to a healthy environment as a basis for justifying these laws. So that's a critically important development. And the last development, which is actually an obstacle to progress, is the presence of investor-state dispute settlement mechanisms in international trade and investment agreements. This is a major barrier to climate action. There has been an explosion in cases brought by foreign investors challenging climate and environmental action. A British investor challenging Italy's ban on offshore oil and gas exploration. Coal companies challenging the phase out of coal in the Netherlands and Germany, forcing the German government to pay $4.5 billion, the government of Italy to pay 200 million euros to a British company that wanted to drill for oil. And as I said, the number of these cases is growing exponentially. The damage awards is growing exponentially. A decision against the government of Pakistan awarded a mining company $5.9 billion in compensation, an absolutely outrageous sum of money in a country like Pakistan, where that's close to the amount of international assistance Pakistan received after the devastating floods. The latest cases filed are even more outrageous. 3 Australian mining companies seeking $37 billion in compensation from the Republic of Congo for not approving mines. 3 times the Republic of Congo's gross domestic product. And a case brought by a Singapore investor against Australia seeking $200 billion in compensation. I mean, these cases are not only making states pay money that should be used for climate action is going to foreign investors, but these cases are also creating a regulatory chill. So we know that Denmark, France, New Zealand, and other countries have actually backed away from critically important climate action because of the mere threat of investor-state cases. So that's a profoundly disturbing development. And just to close on an optimistic note, some countries recognize how important this problem is. A number of European states have withdrawn from the Energy Charter Treaty. And when Canada and the United States renegotiated the North American Free Trade Agreement, Canada and the US got rid of the investor-state dispute settlement mechanism as it applied to those 2 states. So there is progress here. I think that the system, everyone recognizes this is highly problematic, but as lawyers, we have to consign the investor-state dispute settlement mechanism to the dustbin of history. And so thank you for your time and attention here today. Please understand one thing. The climate crisis is a human rights crisis. And when we look at it through that lens, we understand that governments and businesses have obligations, not options, to accelerate mitigation, to pay for adaptation and take the necessary steps, and to provide climate finance on a scale that's commensurate with the level of damage being inflicted on climate vulnerable nations. It's great that there's the establishment of a loss and damages fund, which is operationalized here at COP28, but it's a disgrace that wealthy countries are throwing pennies in the jar. The United States, $17 million, Canada, $16 million. We need hundreds of billions of dollars on an annual basis to deal with the loss and damage being inflicted on climate vulnerable nations. And it's the wealthy countries that have caused and continue to cause this problem that must pay the bill. Thank you very much.
Okay, if I may intervene here, thank you very much, David.
Oh, I'm sorry, Douglas, good.
No, go ahead, Christina, go ahead.
I'm sorry, it's not easy. Because you're behind me, I can't quite see you, but now I do see. Thank you so much, David. Thank you for your keynote, but most importantly, thank you for your consistent work over so many years, so impactful. We would probably not have the recognition of human right to a clean, healthy, and sustainable environment without you. And everyone, if you have not read David's latest report to the United Nations General Assembly, it is on your website. It deals with investor state arbitration and the impacts on human rights, and please read it. Thank you. Douglas, would you like to introduce our next speaker?
Yes, certainly, Christina. Thanks for handing over to me. And if I may, for my own part, say thanks for a very stimulating discussion, David. You certainly brought a lot of information to my attention. To the next speaker, I will now introduce Professor Payam Akhavan, and he is the lead counsel for the small island states. And Prof, if I may have you take the floor now and deliver your address. Over.
Thank you. Good morning, bonjour, and sabah al khair. It's a great pleasure to be addressing this distinguished conference. I will begin perhaps with a poem from my tradition. I'm of Iranian origin. We have a poem written by Sa'di, which appears at the portal of the UN General Assembly in New York, which says, "Human beings are members of one whole, created in essence from one soul. If fate should bring on one part pain, the other parts uneasy will remain. You who have no sympathy for human pain, the name of human you cannot retain." And following in the footsteps of my distinguished colleague, David Voigt, who speaks about the reality of suffering, we have to begin every conversation on climate change by understanding that this is not an academic exercise, it's not an abstraction, and that catastrophic consequences don't await down the road, they are already in process. And I begin this because as a representative of the Commission of Small Island States on Climate Change and International Law, I would remind the audience that small island states are the canary in the coal mine of catastrophic climate change. They understood as early as 1990, just 2 years after Dr. James Hansen popularized the notion of global warming, when the Alliance of Small Island States was established, that climate change would have catastrophic consequences for them. We fast forward 28 years later, in the COP process, which has manifestly failed to address the problem as it should, that some small island states are now concluding treaties, as Tuvalu has with Australia, to relocate its entire population, because in the foreseeable future, that island, unless there is a radical change in the current trajectory, will literally disappear under the waves. And what is happening to them today will happen to the rest of us in the near future. So by raising this issue as they have, they are doing a favor for all of humankind. They're exercising planetary politics. And it was in effect their frustration with the failure of the major polluters to radically mitigate greenhouse gas emissions and to address the issue of loss and damages seriously, that they decided to turn towards international courts and tribunals. And I remember a conversation with one of the prime ministers of the small island states where I explained the basic principle of transboundary harm, that if you conduct activities on your territory which causes significant harm to others, then you become liable. And especially when I put forward the polluter pays principle, the eyes of this prime minister lit up, and he said, "I like this, the polluter pays." And what was incredible about this conversation is the realization that all of the things that they've been fighting so hard for now for almost 30 years in the COP process is already provided for in international law, in binding obligations of states not to cause harm to others, and for the obligation, the duty of reparation, including compensation for the failure to prevent such harm. This was the beginning of the turn towards international courts and tribunals. And it's remarkable historically that the smallest of nations on earth, Vanuatu population 300,000, Tuvalu population 11,000, Antigua and Barbuda population 100,000, are speaking truth to power by leading this remarkable process of raising initially by way of advisory opinions, the question of the obligation of states before ITLOS and the ICJ. In September of 2021, Vanuatu announced its campaign to lead a General Assembly resolution that would refer the question to the ICJ, this being the only way in which the ICJ can exercise advisory opinion jurisdiction through a vote of a UN organ. And of course, that is a very political process, and there were concerns about major polluters preventing small island states from carrying this forward. But then there was yet another back channel, if you like, which was the International Tribunal for the Law of the Sea, established under the 1982 UN Convention on the Law of the Sea, which did not require a UN General Assembly resolution, but simply an international agreement authorizing a body to request such an advisory opinion. So this in part explains the establishment at COP26 by the Prime Ministers of Antigua, Barbuda, and Tuvalu, COSIS, as it has now become known, which included in its charter, among other things, the right to request an advisory opinion from ITLOS. Now, the question is, why ITLOS and not the ICJ, and what is the relationship between the two? Bearing in mind that in March of this year, we had the historic adoption by consensus of a resolution by the UN General Assembly requesting the ICJ advisory opinion. For one thing, ITLOS is a specialized tribunal. It is the guardian of UNCLOS, which is the constitution of the oceans. And we know very well that the oceans are by far the biggest carbon sink in the world, absorbing 93% of excess heat. And we know that the oceans regulate, in effect, the climate system. So the protection of the marine environment is not an insignificant part of protecting the climate system. It is absolutely central. And in 1982, perhaps with a view to addressing issues of oil spills or the dumping of toxic wastes, Part 12 of UNCLOS had a very rigorous set of obligations to protect and preserve the marine environment. The language is that states must take the steps that are necessary to ensure the protection of the marine environment. And once you accept that greenhouse gas emissions are pollution, well, then all of those obligations are triggered. So the power of the case that COSIS has brought before ITLOS is in its simplicity. And to simply wrap up by saying that at the hearing in September in Hamburg, where ITLOS is based, some 50 states and international organizations participated in written and oral statements, and there was overwhelming consensus, as there must be, that greenhouse gas emissions are a pollution, which then triggers the very clear and exacting obligations under Part 12. And we anticipate that there will be hopefully a robust opinion issued sometime in March or April of 2024, which would then hopefully shape and influence the other advisory opinion before the International Court of Justice. It remains to be seen what impact the advisory opinions will have in reshaping the negotiations in future COPs, whether they will even open the way potentially for contentious disputes being brought against major polluters. But at the very least, we can say that we tried what we could to try and put an end to this trajectory, which spells disaster for all of us. So thank you once again for this kind invitation.
Okay, very well. Thank you, Prof, for another stimulating discussion and insights as to where we are. And having hailed from a small state myself, particularly the island of Jamaica, I'm acutely aware of some of the sensitivities that you have just disclosed. And one can only hope, as you have articulated, that we get a robust opinion, because from ITLOS and the other international international tribunals, because I think that would pave the way for a lot of disputes to be settled amicably and we move forward. Because certainly from my jurisdiction, the domestic courts will be looking at that, and all the players in that arena will also be looking to guidance from these international tribunals. So very best of luck with your foray into these different fora. Christina, I'm going to hand over to you now to introduce, I think, what is our final speaker.
Yes, thank you so much, Douglas. Let me also add my thanks to Payam, because it was such an important initiative that you brought rolling, and we are now really at an inflection point in international law when it comes to climate change, thanks to your foresight and to your work. We would like to now invite our dear friend, Professor Patricia Kameri-Mbote. She is the director of the Law Division of the United Nations Environment Program based in Nairobi. Patricia is also a dear friend. She is also a member of the steering committee of the IUCN World Commission on Environmental Law. Patricia, the screen is yours.
Thanks, Christine. It's again my pleasure to be here. And I think starting from your point that we're having inflection in international environmental law, I think it's important to note that since the adoption of the UNFCCC, countries have made a lot of progress to formulate and enact climate change legal instruments. And I think in 2021, it was estimated that every country had at least one climate change law or policy. And this trend is replicated at the regional level, where countries have and continue to adopt regional legal framework agreements to facilitate implementation of climate action within their regions. Coordinated regional responses are indeed critical to implement climate change actions within regional and national circumstances. However, reflecting on the past year, the 2023 UNEP emissions gap report unveiled a stark reality that despite urging nations to fortify their 2030 emission reduction commitments, progress remains woefully inadequate. As greenhouse gas emissions hit new highs, temperature records tumble, and climate impacts intensify, the emissions gap report paints a grim picture. It reveals that the world is heading for a temperature rise far above the Paris Agreement goals unless countries deliver more than they have promised. The 2023 emissions gap report discloses that despite having this high number of climate change laws and policies, their implementation remains a challenge, and their ability to assist countries limit their emissions and address mitigations is limited. In this regard, therefore, there is need to ensure that the laws are robust and comprehensive enough if we are to achieve the below 1.5 degrees centigrade goal. As negative impacts of climate change continue to come to the fore, climate change laws need to take a holistic and cross-cutting approach, including mitigation, responsible investments, and inclusive adaptation responses. The IPCC 6th Assessment Report underscores the pivotal role of inclusive governance and legal reforms in mitigating climate-related risks. It emphasizes the necessity of collaboration between stakeholders, governments, civil society, private sector, local communities, to reinforce the idea that collective action is crucial in addressing the climate crisis. This inclusive approach, cognizant of justice, equity, and gender considerations, emerges as fundamental to our collective resilience. Solutions that mitigate vulnerabilities must be gender responsive and inclusive, engaging civil society, the private sector, and local governments in collaboration with communities most affected. Civil society's role in catalyzing governance reform is undeniable. Individuals worldwide hold governments and corporations accountable for their climate actions through international tribunals and national courts. We just had the issues raised on behalf of small island states. The total number of climate change cases has more than doubled at the national level, from 884 in 2017 to 2,180 in 2022, from the recent UNEP Global Climate Litigation Report 2023. The report additionally demonstrates that the voices of vulnerable groups are being heard globally. And I think this is what David Voigt was talking about. 34 cases have been brought by and on behalf of children and youth under 25 years of age, including by girls as young as 7. Climate litigation grounded on human rights has increased over time, both nationally and regionally. According to the second UNEP Environmental Rule of Law Report 2023, discussion on the recognition of a right to a clean, healthy, and sustainable environment is influencing the arguments used in climate litigation around the world. Landmark UN General Assembly resolutions affirming the right to a clean, healthy, and sustainable environment is only likely to reinforce this momentum, enabling all stakeholders to intensify efforts toward fulfilling these fundamental human rights. Climate change litigation also challenges government inaction or feeble action to address climate change. And within the realm of UNEP, we have made significant strides, as I mentioned earlier. The national focal points of the Montevideo Program 5 highlighted legal responses to climate as one of the key priorities for implementation. UNEP's law division has been instrumental in providing technical support, knowledge dissemination, and training in climate change to governments and stakeholders globally. However, the 2023 reality demands more than commendable efforts. It demands resolute action. The emissions gap report, and I hope many of you have seen it, it serves as a clarion call, and the subtitle for that report was Broken Record. Temperatures hit new highs, yet world fails to cut emissions, and in brackets, again, warning us that our window to avert climate catastrophe rapidly diminishes. Incremental change is no longer an option. Each degree of global warming disproportionately affects vulnerable communities, women, indigenous peoples, and future generations. Today, as we engage in discussions and deliberations, let us amplify our endeavors, leveraging our collective experiences, successes, and challenges. Let us forge a path towards stronger, more effective climate law and governance, embedding equity, justice, and inclusivity at its core. Encouraging direct engagement or outlining specific actionable steps for the audience to take after the event can enhance the effectiveness of the actions we take today. In closing, I urge you to heed the urgency of this moment. Let us channel our discussions today into action, seizing every opportunity to drive change, protect our planet, and secure a sustainable future for generations to come. Inspiring the audience to be proactive in their respective spheres can create a lasting impact beyond the event itself. And I'd go back to what Christina said, that the science is clear, and what we now need is law, because if we look to political will, it is also not as resolute. So let us go on the science and take action. Thank you.
Thank you so much, Patricia, again for your keynote here, but most importantly as well for the very important work that UNEP does in promoting the environmental rule of law across the whole spectrum of environmental challenges, but in particular when it comes to climate change. You work as well with the judiciary, but then also the emissions gap report with the very important title, Broken Records, this year. Again, dear friends, dear colleagues, I think this takes us to the end of this first plenary session. And I turn to you, Douglas, in a second to give the final word. But we hope that it gave you appetite for more discussions throughout the day. It was really only the opening plenary, and we will go in much more detail in the discussions to follow. Douglas, back to you for a closing remark.
Yes, thank you, Christina, and thanks to all the panelists. Your talk and the insights have been very stimulating. From Christina, who, as we say on this side of the globe, from what we call cricket, you opened the batting, Christina, and it was good to hear that the committee, the Rules Committee, is now operational, and you are in your own unique way bringing those errant countries into compliance by using the carrot and the stick to get them coming along. It was good to hear that, and also that you gave the segue to David, who introduced us to the various workings of the international tribunals and the impact of human rights and how climate is impacting human rights and how these tribunals are being approached to give guidance on the various activities ranging from Chile to Botswana, etc. So those were some pretty good insights. And also what is dear to my heart, Prof. Payam Akhavan had given us the insight from the small states perspective and what is being done, the activities of Antigua and the other small states which have approached ICLOS and other international tribunals to get some kind of an advisory opinion as to the polluter pay principle. And what was most revealing is that these are already embedded in international law, and the fact that parties are using these as galvanizing them into action as far as climate resolving the climate crisis is concerned. And this takes us back to the earlier point you made, Christina, that the Paris Agreement really sets the framework, but it's not a panacea. States will have to help themselves, so to speak, to ensure that we all overcome the climate crisis. And Patricia, who gave us some very good statistical information. It's good to hear that the cases are increasing, almost doubled from 2018 to 2023. It was depressing on the emission standards and where we are now, but we understand the rationale for that. And it goes back to a point I think David made earlier, which is that countries need financing to ensure that they can meet these various standards. And the sooner we get to that realization, the better it will be for all of us. So I think overall, we had a very stimulating discussion. The audience, I'm sure, would have appreciated the insights. And certainly for myself, speaking for myself, I know where to go and look for some of the information, and we'll be perhaps in touch with the panelists on a one-on-one to follow up on some of the interesting insights that they have imparted to us today. Now, I know we're well over time, so without any further delay, on behalf of my co-host, we would now bring this plenary to an end. And thank you all. You've been a very wonderful panel and a wonderful audience. Thank you all.
Thank you. Thank you very much. We heard in the opening plenary that it was time for action. Now it's time to take a very short break as we move towards our next session of concurrent expert panels.